Your spouse is standing at a U.S. consulate window with a folder that took you 2 years to assemble: medical exam, police certificates, affidavits, photos, proof of relationship, plane plans, and then, without a denial, without a hearing, without a single new document requested, the clerk slides the passport back and says, "Processing is paused." Not delayed, not backlogged, paused. That one word is how governments do silent confiscation. They don't have to slam the door in your face. They just remove the doorknob and act like it's normal. And if you're from one of the 75 countries now caught in this new immigrant visa freeze that took effect January 21st, 2026, you're watching something far worse than a policy shift. You're watching a system learn, again, how to separate families at scale using bureaucracy as a weapon. And here's the part you need to understand right now, because it's where most people make the devastating mistake. This freeze is not evenly applied, it's not clean, and it's not fair. It's a regulatory dragnet with exceptions baked in. Exceptions most people will never hear about until it's too late. If you stay with me, I'm going to walk you through what this freeze actually does, why the public charge story is the cover narrative, which categories are truly trapped, and the narrow corridors that still let people through. One of those corridors, if you qualify, can change your entire timeline. But another workaround that people are trying right now can permanently poison your case, and I'll tell you exactly what it is before we're done. This is Immigration News Desk. And today, I'm not doing a feel-good update. I'm doing an autopsy of how an administration can freeze millions of lives overnight without passing a new law, without a vote, and without a clear end date. Because if you think this only affects other people, you're not seeing the larger systemic risk. Once the government proves it can pause immigration by memo, every visa category becomes a lever, every family becomes collateral, and every consulate becomes a gate controlled by political weather. Let's strip away the noise. Immigrant visa processing frozen means consular processing, embassies and consulates abroad, are being instructed not to issue certain immigrant visas for nationals of designated countries. That's the green card pipeline that runs through the State Department. It's the final stretch after USCIS approves a petition, after the National Visa Center collects fees and documents, after you've already spent months, sometimes years, following the rules. And that's why it's so psychologically violent. It hits at the finish line when your family has emotionally moved in already. The freeze, as described in the announcement and reinforced by internal cables circulating among posts, is primarily slamming family-based immigrant visas. Spouses, parents, children. In some cases, it's also catching employment-based immigrant visas that were approaching issuance, people who did perm labor certification, survived the recruitment gauntlet, found an employer willing to bet on them, and now get told the last step is paused. You need to grasp the geometry of the trap. If you're outside the US and your only path is consular processing, you are at the mercy of a consular machine that can be throttled with a cable. Consular officers have enormous discretion. They can place you into administrative processing. They can request more documents. They can delay. And when Washington says pause, you don't get a courtroom the next day. In most cases, you get silence. That's why families describe it as a disappearance. Your case doesn't die. It just stops living. Now, January 21st, 2026 is being treated as the line in the sand. Anything interviewed or issued before that date may keep moving. May. And that may is not me being dramatic. That may is the point. The government can allow some pre-freeze cases to complete while using additional review to slow others. And if you're thinking, okay, so what's the rule exactly? That's the wrong question. The real question is, what's the mechanism? Because when you understand the mechanism, you can find the seam. The stated justification being pushed publicly is public charge concerns. You've heard the phrase, but most people don't understand what it really is. A legal concept turned into a political tool. Historically, public charge meant the government could deny admission or permanent residence if it believed you were likely to become primarily dependent on government assistance. The idea exists in U.S. immigration law going back more than a century, and it has always been elastic, an interpretive lever. Different administrations stretch it or relax it. In the late 2010s, it became one of the sharpest blades in the toolbox. Broadened definitions, more scrutiny on financials, heightened fear in immigrant communities, and a chilling effect where even eligible families avoided benefits out of panic. It's not just law, it's behavioral control. So when an administration says, "We're freezing immigrant visas because of public charge risk," you should hear what that really means in bureaucratic language. We are asserting a predictive suspicion about future dependency and using it to justify mass friction. It's pre-crime logic applied to family unity. And the reason this matters is because it signals how exceptions will be framed. If the theory is risk of dependency, then exceptions will cluster around economic self-sufficiency, strategic national benefit, and special classifications that let the government say, this person isn't a burden, this person is an asset. That's the first open loop I want you to hold on to, because in a few minutes I'm going to show you the exception category that quietly turns that logic against the policy itself. Before we get to pathways, you need to understand scope. 75 countries is not a normal list. That's not a scalpel, that's a net. And the list, based on the reporting and the examples already circulating, cuts across continents, parts of Asia, Europe, Africa, Central America, the Caribbean. Some names on it will not match the public's intuition. You can find the compiled list our team is tracking through Immigration News Desk resources, and you should verify your exact situation with official notices and your legal counsel, because lists can shift, posts can interpret guidance differently, and national of can become its own fight in edge cases. But the point isn't memorizing 75 names. The point is recognizing what kind of policy this is. A mass designation approach where the government doesn't have to prove anything about you individually. Your passport becomes a risk score. And here comes the second open loop, because it's where families blow up their own cases. People assume a freeze equals a denial, so they panic, withdraw, refile, change categories, or try clever shortcuts. Some of those moves are irreversible. There is one specific impulse, especially among couples, that feels rational in the moment and can later be characterized as misrepresentation or abuse of process. I'm going to tell you what it is after we clarify which visas are actually being targeted, because the distinction is where the strategy lives. This freeze, based on the guidance described, is aimed at immigrant visas, categories that lead directly to lawful permanent residence through consular issuance. That means the traditional family-based immigrant visas and certain employment-based immigrant visas processed abroad. What it does not automatically mean is everything stops. Non-immigrant visas, tourist, student, temporary work are, at least as described right now, not the primary target of this specific freeze. That matters because the U.S. immigration system is two parallel rivers: the State Department's consular visa issuance abroad and USCIS processing inside the United States. When the State Department river is dammed, people look for tributaries. If you're applying for a visitor visa, a student visa, or a temporary work visa, the freeze, again, based on what's being described, does not categorically shut you down. But do not misunderstand what I'm saying. Not categorically shut down is not safe. Consular officers can scrutinize you harder if your country is designated. They can question your ties. They can question your intent. They can deny you for standard reasons even if the freeze doesn't apply. The climate changes the vibe at the window, and in immigration, vibe becomes outcome. Now let's talk about the question everyone asks first, because it's the most time-sensitive. I already have an interview scheduled after January 21st. Do I still go? Yes, you go. You do not skip it. Skipping an interview can be interpreted as abandonment, and even when it's not, you lose your place in a system that punishes absence. Reports from posts indicate interviews are still being conducted in many instances, even after the effective date, especially for cases that were already scheduled before the announcement detonated. Why would they interview you if they might not issue? Because the government likes optionality. Conducting the interview lets them finish the fact-finding, lock in your testimony, and then park you in administrative processing if they want. That's not kindness. That's leverage. But you still attend because a completed interview can be the difference between a case that is ready to issue when the freeze lifts versus a case that has to re-enter a congested queue. And yes, you need to prepare for the magic phrase, 221G. Administrative processing. It sounds neutral. It is not neutral. It is a holding pen that can last weeks, months, sometimes longer, and it can be used as a pressure valve to slow issuance without formally denying you. If your case is placed into 221G, you follow instructions precisely, you document everything, and you do not improvise. Improvisation is how people create contradictions that live forever in consular notes. Second question. I was approved, but my passport hasn't been returned. This is where the freeze becomes psychologically cruel. Some approvals may still be finalized if they were effectively completed before the cutoff, but you should treat any UN-issued visa as not yours until it's in your hand. Consulates can hold passports for printing. They can reverse course. They can request further review. Your job is to monitor your case status, watch for emails, and, this is key, do not make irreversible life decisions until you physically have the passport back with the visa foil and you understand the travel validity. Third question. How long does it last? Paused until further notice is the bureaucrat's favorite phrase because it shifts your life into indefinite limbo while preserving the government's flexibility. If you're waiting for an end date, you're going to hemorrhage time. You have to behave as if the freeze could persist long enough to reshape your entire plan, while simultaneously preparing for it to lift suddenly, causing a stampede at consulates. That paradox, prepare for long and short, is what makes families misstep. And the next open loop is this. The people who lose the most time aren't always the ones blocked by the freeze. It's the ones who are technically exempt but don't realize it, and they sit still while the window is still open. If that could be you, listen carefully, because we're entering the part most channels bury in vague optimism. The first exception, and the cleanest seam in the policy, is dual nationality. If you are a citizen of two countries, and only one of those countries is on the designated list, your non-designated citizenship can change the entire analysis. But you have to do it correctly. This is not just show a second passport like it's an airport lounge trick. It can require transferring case processing to a post where you can apply as the non-designated national, and it can require aligning your DS-260 and file identifiers with the nationality you're invoking. In practical terms, if you're a dual national with, say, one passport from a listed country and another from a non-listed country, you may be able to proceed under the non-listed nationality. That is a rare form of legal oxygen right now. And it's time-sensitive, because as backlogs grow, posts can get overwhelmed, and procedural steps start taking months. The second exception is the one that weaponizes the government's own stated rationale, national interest. Different administrations label this differently, but the concept is consistent. If the United States has a compelling interest in your entry, critical healthcare work, specialized research, strategic industries, urgent humanitarian adjacent roles tied to U.S. priorities, there may be a waiver mechanism or exception path that can be requested. This is where I need you to stop thinking emotionally and start thinking like an investigator building a brief. National interest is not a vibe. It's an evidentiary package. You need documentation that demonstrates scarcity of your skills, urgency of your role, and concrete benefit to U.S. interests. Letters from employers, hospital systems, research institutions, government-affiliated partners, and proof of licensing timelines can matter. Timing matters, clarity matters, and legal framing matters, because you are not just asking for mercy, you are arguing that denying you harms the United States. But here's the trap. People hear national interest and assume it's only for celebrities and Nobel laureates. That's wrong. In past restriction regimes, healthcare workers and specialized technical workers have had viable arguments, especially when backed by real operational need. If you're in nursing, medicine, lab science, elder care pipelines, public health, or specialized engineering tied to infrastructure, you might be closer to an exception than you think. And the devastating mistake, one of them, is waiting until your interview is already in limbo to start assembling the waiver. By then, you're begging the machine to move you. You want to hand them a completed rationale before your file becomes another frozen number. Now, the third pathway is the one that most people don't understand until someone tells them bluntly, if you are already inside the United States, this particular consular freeze may not stop you from pursuing permanent residence through adjustment of status if you're eligible. That's not a loophole. That's a structural divide in the system. Consular processing abroad is one track. Adjustment of status through USCIS inside the US is another track. If you're in the US on a lawful non-immigrant status and you have a qualifying basis to adjust, family petition, employment petition, other qualifying categories, this freeze, as described, does not automatically bar you from filing an I-485 package. And that is why travel decisions become life-altering right now. If you're in the United States and you leave, you can force yourself back into the consular pipeline. You can take yourself from the track that's still moving, however slowly, to the track that is literally paused. People do this every year by accident through routine travel, family emergencies, weddings, funerals. I'm not telling you never leave the country. I'm telling you that leaving without a strategy, without counsel, and without understanding how your return would be processed is how you turn a manageable case into a multi-year exile. And if you remember my earlier promise about the workaround that can poison cases, we're almost there. Because it usually starts with travel panic and ends with a consular officer deciding you lied. Let me also clean up the misinformation swirling right now, because panic spreads faster than policy. This freeze, as described, is not the same thing as green card renewal. If you're a lawful permanent resident renewing or replacing a green card, Form I-90, that's a different mechanism. Certificates of citizenship, replacement documents, N-600 filings, these are not immigrant visa issuances abroad. Different agencies, different authority lanes. People hear freeze and assume everything is suspended. That's how scammers sell fear. You need to separate what is paused from what is merely slow. Now, fiancés. K-1 fiancé visas occupy a strange borderland. They are technically non-immigrant visas, but they are designed with immigrant intent and lead to adjustment of status after marriage. In prior restriction eras, K-1s have sometimes remained technically available even when immigrant categories were hammered, until guidance tightened. Based on early signals described in the source material, K-1s do not appear to be explicitly included right now, but you should not treat that as permanent safety. You should treat it as a window that can close. If you are a U.S. citizen engaged to someone from a designated country, the K-1 may be a viable route, but only if you execute it correctly and ethically. And now, the non-immigrant strategy, which is where desperation meets the misrepresentation cliff. People are hearing, non-immigrant visas aren't frozen, and they're thinking, fine, I'll just get a tourist visa, enter the U.S., and then adjust status. Sometimes, in limited circumstances, that can be lawful if the person enters genuinely intending a temporary stay and later has a bona fide change in circumstances that creates eligibility. But if you apply for a tourist visa while secretly intending to immigrate immediately, you can trigger allegations of fraud or willful misrepresentation. That is not a slap on the wrist. That can create a permanent inadmissibility problem that requires a waiver, if a waiver is even available for your category. This is the devastating mistake I warned you about. Using a visitor visa as an immigrant visa substitute with pre-planned intent, then leaving a trail of messages, payments, and plans that make it obvious. You need to hear this clearly because no one says it loud enough on YouTube. Consular officers and USCIS adjudicators don't just read forms. They read patterns. They look at timing. They look at prior filings. They look at whether your story makes sense. If the system believes you used a temporary visa as a backdoor around a freeze, you've just handed the government a moral narrative to deny you. They don't follow the rules. And once you become that story in the file, you can spend years trying to escape it. So what do you do if you're overseas, your immigrant visa is paused, and you genuinely qualify for a non-immigrant category like F1 student or H-1B specialty worker? You pursue it honestly, with an application that is consistent, truthful, and supported. You do not launder immigrant intent through a category that requires non-immigrant intent. And you do not take advice from comment sections or visa agents who will disappear the moment your case implodes. Let's zoom out for a moment, because the history matters. This is not the first time the U.S. government has used nationality-based restrictions or administrative throttling. In 2017, we watched travel bans ricochet through courts, airports, and families. We watched waivers exist on paper while being nearly impossible in practice for many. The lesson from that era wasn't just that restrictions happen. The lesson was that the system adapts to resistance by moving from blunt bans to more technically defensible friction. Heightened screening, expanded administrative processing, quiet pauses, policy review, internal checklists that never get published. It's asymmetric warfare against your timeline. You are expected to run your life on a clock. They are allowed to run the government on further notice. And that's why your mindset has to change. If you're affected, you cannot sit in passive hope. You need an action posture, not reckless action, strategic action. Here is what you do, in order, without self-sabotage. First, confirm whether your nationality is on the affected list and confirm what national of means in your situation. Dual nationals, permanent residents of third countries, people with complex documentation. These details can change jurisdiction and options. Second, if you have an interview scheduled, you attend. You bring a complete file. You treat it like issuance is possible, because for some people it still is, especially those already in the pipeline. Third, if you are a dual national, you explore rerouting immediately, case transfer, post-jurisdiction, and nationality alignment. Fourth, if you might qualify for national interest, you start building the evidence package now, not later. Fifth, if you are inside the United States and eligible to adjust status, you seriously consider filing rather than waiting, because policy risk compounds with time. Sixth, you reconsider international travel if leaving would push you into consular processing. This is not fear-mongering. This is recognizing the difference between two bureaucratic universes. Seventh, this matters more than people admit. You document everything. Save communications, save notices, track dates. If you later need to prove unreasonable delay, demonstrate reliance, or challenge a procedural failure, your paper trail becomes your power. And yes, there are legal pressure tools in certain delay scenarios. Congressional inquiries, ombudsman requests for USCIS matters, and in some contexts, federal litigation strategies like mandamus or APA claims aimed at unlawful withholding or unreasonable delay. Those are not magical, they are not guaranteed, and consular processing comes with unique barriers. But the point is, you have more leverage when you act early and build a record, not when you wait silently for months and then scramble in despair. Now let's talk about the emotional center of this. You're not crazy if you feel hunted by paperwork. You're not dramatic if you feel like your family is being used as a policy demonstration. That's what mass freezes do. They convert private love into a public statistic. But you also need to understand something that will protect you. The system feeds on confusion. Confusion makes you miss interviews. Confusion makes you abandon petitions. Confusion makes you lie to yourself about quick fixes. Confusion makes you spend money on bad advice. Clarity is resistance. The hard truth is that this freeze is designed to create a liquidity trap in human terms. Your time, your money, your hope, all locked in an account you can't access. But the other truth, the one you should hold on to, is that the same bureaucracy that can pause you can also be navigated if you understand where discretion lives and where the rules still bind the government. That's why exceptions exist at all. Exceptions are the tell. They prove the policy is not a law of physics. It's a choice. And I want to leave you with one final open loop turned into an actionable warning. The next few weeks are when scams bloom. When governments create uncertainty, predators sell certainty. If someone promises you a guaranteed visa, a guaranteed waiver, a guaranteed inside contact, you are being lined up to be robbed, or worse, pushed into fraud that will stain your record permanently. You don't need magic. You need lawful strategy. If this freeze touches your family, your work, your marriage, your future, I want you to stay close to verified updates and avoid rumor-driven decisions. We will keep tracking developments, post-by-post implementation patterns, and any documented exception trends as they emerge. If you want more deep-dive reporting like this, where we don't just repeat the announcement, we dissect the machinery, subscribe here on Immigration News Desk, because the only way to survive a bureaucratic trap is to see the trap before you step in it. And if you take nothing else from this video, take this. You are not powerless, but you are on a clock that the government refuses to acknowledge. Don't waste your clock. Verify your category. Attend your interview. Don't lie your way into a workaround. Build the waiver case if you have one. And if you're inside the United States and eligible to adjust, think very carefully before you gamble your position on travel or delay. This isn't the end of your American dream, but it is a stress test. And how you move in the next 30 days, quietly, strategically, legally, can determine whether you're reunited soon or whether you get stuck in further notice for years. Thanks for watching Immigration News Desk. Keep your documents tight, your story consistent, and your next step deliberate, because right now, the system is not forgiving.